Welcome back everybody. So today we will be doing about order 38, that is arrest and attachment before the judgment. Arrest and attachment. This order is important for your pre as well as mains point of view, and we will make sure that we do it entirely perfectly. Okay. Now order 38 rule 1, where defendant may be called to furnish security for his appearance. Basics, let's clear. We are doing arrest. We will do the rest of defendant. Okay. We are attaching property. We can attach property of anybody, not just defendant. Let's just see. Let's just ask. Okay. Let's just consider this for a moment. So where the defendant may be called upon to furnish security for his appearance. Plaintiff will be able to give his appearance because he is instituting the case. The other party, we need to make sure that he appear also, is the defendant. Okay. Just a second. So under 38, rule 1, we are furnishing security where at any stage of the suit, other than the suit of nature referred to in section 16 clause A to D, the court is satisfied by affidavit or the otherwise that the defendant with intent to delay the plaintiff. Now defendant has the intention to delay the plaintiff or to avoid any process of the court or to obstruct or delay the execution of any decree that may be passed against him. What he has done, he is intending to do, he is intending to delay, he is intending to avoid, he is intending to obstruct execution, avoid process of the court and delay plaintiff. In all such circumstances, has absconded or left the local limits of the jurisdiction with the intention. He has left the absconded or left the local limits of the jurisdiction. He is about to abscond or leave the local limits, or he has disposed of or removed from local limits his property or any part thereof. And the defendant is about to leave India under circumstances affording reasonable probability that plaintiff will or may thereby obstruct or delay an execution decree that may be passed against the defendant's suit. Now what will do? The court may issue a warrant. The court will issue a warrant to arrest the defendant, bring him before the court to show cause why he should not furnish security for his appearance. Just to secure all these, secure the fruits of the decree, then the court will issue warrant of his arrest. Okay. Court will issue arrest warrant and bring him before the court to furnish security. Court may issue a warrant to arrest after the defendant and bring him to the court, provided the defendant shall not be arrested. Now he will not be arrested if he pays to the officer entrusted with the execution of the warrant any sum specified in the warrant as sufficient to satisfy the plaintiff's claim, and such sum shall be held in deposit by the court until the suit is disposed of until the further order of the court. Now he will not be arrested. Why? In the warrant, any sum if has been mentioned, defendant pays that, then he won't be arrested. Now what will this amount be? This amount will be deposited in the court till the further orders or the suit is disposed of. Okay, cool. Next is security. Order 38 rule 2 talks about security. So where the defendant fails to show cause why the court shall order him either to deposit in the court money or other property sufficient to answer the claim against him or to furnish security for his appearance at any time when called upon while the suit is pending and until satisfaction of the decree that may be passed against him in the suit, and make such orders a thing with regard to the sum which may have been paid by the defendant in this proviso to the last preceding rule. Every surety for appearance of this defendant shall bind himself. Every surety will bind himself in default of such appearance to pay any sum of money which the defendant may be ordered to pay in the suit. Third, procedure on application by surety to be discharged. Two may we introduce this surety, we bound himself. Now he's so terrified that that defendant obviously would not pay, and he would have to take the burden upon himself. So under 3 he says, let me be please discharged. A surety for appearance of the defendant may at any time apply to the court in which he became surety to be discharged from his obligation. On such application being made, the court shall summon the defendant to appear, or if it thinks fit, may issue a warrant for his arrest in the first instance. So after the discharge on such application shall summon the defendant or warrant. Anything it can do. On the appearance of the defendant in pursuance of the summon or warrant or his voluntary surrender. So he can appear or he can voluntarily surrender. The court shall direct the surety to be discharged from his obligation, shall call upon the defendant to find fresh security. Same provisions we find in the CRPC. Can you please comment down below what provisions of these of like nature you find in the CRPC? Next, we have procedure where defendant fails to furnish security or find fresh security. Now the defendant is unable because he just had only one friend that agreed to be surety, and now he is also being back out. He also backed out from it. Now he did not have any. So where the defendant fails to comply with any order of Rule 2 or Rule 3, the court may commit him to the civil prison. So the court will only do one thing. He will commit him to the civil prison until the decision of the suit, or where decree is passed against the defendant until the decree has been satisfied. So there is no limit to it. Provided that no person shall be detained in prison under this rule in any case for longer period than 6 months, nor for longer period than 6 weeks, when the amount of the value does not exceed 50 rupees. 50 rupees we have 6 weeks, and for more than 50 we have 51 rupees upper we have 6 months. Okay, so this is the amount of time that the court can now everything is above 50 rupees, so 6 months would be the maximum time period where the court can commit him to the civil prison. Okay, 6 months and 6 weeks and 50 rupees. Provided also that no person shall be detained in prison under this rule after he has complied with such order. No person detained after he has complied with such order, so you have to release it after that. We have done arrest. Now let's do attachment before the judgment. Attachment of property. So where defendant may be called upon to furnish security for production of property. Now defendant has been asked to furnish security for production of property, where at any stage of the suit the court is satisfied. Now how it is satisfied? By the affidavit or otherwise, that the defendant with intent to obstruct or delay the execution of decree that may be passed against him is about to dispose of the whole or any part of his property, is about to remove the whole. So it is the fear of the plaintiff that the defendant is about to dispose whole or of any part of the property, or is about to remove the whole or any property from the local limits of the jurisdiction. About to remove, dispose. The court may direct the defendant within a time to fix bed either to furnish security. So court what will do? Court will do that ask a defendant to furnish security in such sum as may be specified, to produce and place at the disposal of the court when required the said property, the value of the same, or such portion thereof as may be sufficient to satisfy the decree, or to appear in show cause why he should not furnish security. The plaintiff shall, unless the court otherwise specify the property required to be attached and estimated value thereof. So what is the duty of the plaintiff? The duty of the plaintiff is to specify the property that is to be attached and the estimated value. The court may also in order direct the conditional attachment of the whole or any portion of the property so specified. If an order of attachment is made without complying the sub-rule 1 of this rule, shall attachment be void. What is sub-rule 1? This is the sub-rule 1. If it is not there, then such attachment shall be void. Okay. 6. Attachment where cause not shown or security not furnished. Where the defendant fails to show cause why he should not furnish security, and he fails to furnish the security required within the time fixed by the court may order the property satisfy such portion thereof as appears sufficient to satisfy be attached. Where the defendant shows such cause, the court shall order the attachment to be withdrawn or make such order as things. If he shows, then it could be withdrawn. Mode of making attachment. Save as otherwise expressly provided, the attachment shall be made in the manner provided for the attachment property In execution of the decree, adjudication of claim. Where any claim is preferred to property attached before judgment, such claim shall be adjudicated. Herein provided for the adjudication of claim to property executed for the payment of money, removal of attachment, pair security furnished or suit dismissed. Now the suit is dismissed, then your attachment would be removed and security furnished would be recovered. So when order is made for attachment before judgment, the court shall order the attachment to be withdrawn when the defendant furnishes security required together with the security for the cost of the attachment. Attachment before judgment not to affect rights of strangers or bar decree holder from applying for sale. Attachment not to affect rights of stranger, not decree holder from applying for sale. So shall not affect existing prior of attachment before judgment shall not affect the rights existing prior to the attachment of persons of not party to the suit, nor by any person holding a decree against the defendant from applying for the sale of the property under attachment. Property attached if a judgment not to be reattached in execution of the decree. Obviously, how could it be reattached? Where the property is under attachment by virtue of the provision of this order and the decree subsequently passed in favor of the plaintiff, it shall not be necessary upon an application of the execution of such decree to apply for reattachment of the property. Is under attachment by virtue and decree subsequently passed in favor of the plaintiff. 11A. Provisions applicable to attachment. The provisions of this code applicable to an attachment made in execution so as may be applied to attachment made before judgment which continues after the judgment by virtue. Attachment made after the judgment suit which is dismissed for default shall not become revived merely by reason of the fact that the order of dismissal of suit has been set aside and the suit has been restored. Not an attachment made before judgment in a suit in which the dismissed for default shall not become revived merely by reason of the fact. So Liklo shall not become revived merely by reason of the fact that the order of the dismissal of the suit of the default has been set aside and the suit has been restored. Agricultural produce not attachable before judgment. Now, nothing in this order shall be deemed to authorize the plaintiff to apply for attachment of any agricultural produce in the possession of any agriculturalist or to empower the court to order attachment or production of such produce. Small causes court not to charge immovable property. Nothing in this order shall be deemed to empower any court or small causes to make an order for the attachment of the immovable property. 13 आता है small causes immovable नहीं कर सकता. 12 आता है आपके प्री में एग्रीकल्चरल प्रोड्यूस आपकी नहीं हो सकती अटैच. आपका ये वाला प्रोविज़न आता है इट वोंट बी शैल नॉट बिकम रिवाइव नहीं होगी. आपका जो प्रोविज़न आता है इन द PYP इज दिस दैट इज़ एग्जिस्टिंग प्रायर टू अटैचमेंट, आपका उसको भी इफेक्ट नहीं करेगा. Then the other thing that in the time period 6 months 6 weeks that we did do in the attachment, we did in the rest, right? Arrest, yes, defendant phase of unsecured we did in arrest. And then this is 5 and that it becomes void. This comes under in your prelims. Okay, so we have done order 38 as well. In the next session we will be doing order 37 and order 36. Order 37 is the summary procedure, very important, and 36 we know special case, right? With 9 that is friendly suit. Okay, and 35 is interpleader. We will also do 35 interpleaders. I guess we are doing something good. Let's just do one more order and then we can call it a day. Okay, let's do summary procedure as well. Order 37. Order 37 talks about summary procedure. Now this order holds importance for your pre as well as your mains point of view. The codes and classes of suits to which order is to apply. Now summary procedure in the civil suit and the criminal trial is a little bit different. The code and classes of which the order is to apply. This order shall apply to the following courts: High Court, City Civil Court, Court of Small Causes, other courts. Now other courts is so wide, and provided that in respect of the courts referred to in clause B, the High Court may by notification in the official gazette restrict the operation of this order only to such category of suit as it deems proper, and may also from time to time as the circumstances of the case may require by subsequent notification in the official gazette, further restrict, enlarge, or vary the categories of the suit to be brought under the operation of this code order as it deems proper. Subject to the provisions of Rule 1, order applies to the following classes of suit. We have done courts हमने कर लिए. अदर कोर्ट्स का ये मतलब है आपकी हाई कोर्ट जो है वो नोटिफिकेशन लाएगी ऑफिशियल गैजेट में, वो रिस्ट्रिक्ट करेगी इस ऑर्डर को कि ये नहीं होगा. ठीक है, वह सब्सिक्वेंट नोटिफिकेशन ऑफिशियल गैजेट एनलार्ज कर सकती है, वेरी कर सकती है, वो चीज़ है. कूल. नाउ कोर्ट हो गए. नाउ आते हैं हम केसेस पे, ऑन विच केसेस समरी प्रोसीजर अप्लाइज. तो इट अप्लाइज अपॉन बिल्स ऑफ एक्सचेंज, हुंडीज और प्रॉमिसरी नोट्स. तो नेगोशिएबल इंस्ट्रूमेंट्स के ऊपर आपका समरी प्रोसीजर अप्लाई कर सकता है. सूट्स इन विच द प्लेंटिफ सीक्स ओनली टू रिकवर अ डेट और लिक्विडेट डैमेज इन डिमांड इन मनी पेएबल बाय द डिफेंडेंट विद और विदाउट इंटरेस्ट. Now a second where the summary procedure would be there is that of suit in which plaintiff is only seeking to recover a debt or liquidate a demand, okay, in which money payable by defendant. Simple. On a written contract, summary procedure. On an enactment where the sum sought to be recovered is a fixed sum of money or in the nature of debt other than the penalty. enactment में आपको कुछ रिकवर करना है जो फिक्स सम ऑफ मनी है, जो पेनल्टी नहीं है. On a guarantee where the claim against the principal is in respect of a debt or liquidated demand only. Okay, 3 cases. In these cases, not 3 cases, on bill exchange, hundi and promissory note, where the plaintiff seeks money. मनी किस किस के अंडर से कर सकता है, आस्क कर सकता है. कॉन्ट्रैक्ट, रिटन कॉन्ट्रैक्ट, इनैक्टमेंट के अंदर जब वो पेनल्टी नहीं है, और गारंटी के अंदर अगेंस्ट द प्रिंसिपल इन रिस्पेक्ट ऑफ द डेट और लिक्विडेटेड डिमांड ओनली. डेट और लिक्विडेटेड डिमांड के ऊपर ये समरी प्रोसीजर चल सकता है. ना आप इंस्टीट्यूट कैसे करोगे समरी सूट को. सो सूट टू विच दिस ऑर्डर अप्लाइज में इफ़ द प्लेंटिफ डिज़ायर टू प्रोसीड हियर अंडर बी इंस्टीट्यूटेड बाय प्रेजेंटिंग अ प्लेंट. आप प्लेंट लगाओगे, सिंपल, एंड शैल कंटेन. अब उसके अंदर आपके क्या होना चाहिए, प्लेंट के अंदर में आपको होगा स्पेसिफिक एवोमेंट टू द इफेक्ट दैट द सूट इज फाइल्ड अंडर दिस ऑर्डर. स्पेसिफिक एवोमेंट मतलब इन द प्लेंट इटसेल्फ यू विल राइट दैट दिस इज फाइल्ड अंडर ऑर्डर 37 ऑफ CPC, दैट नो रिलीफ विच डज नॉट फॉल विद इन द एम्बिट ऑफ दिस रूल हैज़ बीन क्लेम्ड इन द प्लेंटिफ. नो रिलीफ विच इज आउटसाइड or 37 has been asked. You have to like specifically write the following inscription immediately below the number of the suit and the title of the suit, and under the title of the suit you have to mention this under order 37 of the CPC 1908. You have to mention this. Summons of the suit shall be in the form 4 appendix B in such other form as may be from time to time be prescribed. और ठीक है, तो फॉर नाउ आपका फॉर्म नंबर 4 है अपेंडिक्स बी में. If defendant shall not defend the suit referred to in sub rule 1 unless he enters an appearance, and in default of his entering an appearance the allegations in the plaint shall be deemed to be admitted. This is important, okay, this is important. Now read very clearly and attentively. Defendant shall not defend. Now we are not giving him the right to defend unless he enters an appearance, and in default of his entering an appearance we will do, this is a big thing, we will admit, will deem that plaint whatever has been written in the plaint has been admitted, and plaintiff shall be entitled to decree for any sum not exceeding the sum mentioned in the summons, together with interest at rate specified if any up to the date of the decree, and such sum for cost as may be determined by the High Court from time to time by rules. कॉस्ट आपकी हाई कोर्ट देगी, ठीक है, कॉस्ट आपकी हाई कोर्ट बताएगी, इंटरेस्ट आपका वो होएगा बाय मीन्स इन सच डिक्री में बी एग्जीक्यूटेड फोर्थ विद. इज दिस क्लियर? लाइक दिस इज अ बिग थिंग दैट वी आर पुटिंग ऑन द डिफेंडेंट. नेक्स्ट इज वी हैव प्रोसीजर फॉर अपीयरेंस ऑफ डिफेंडेंट. Now under rule 2 we said that if you have not entered your appearance then we will deem that you have admitted all the allegations that the plaintiff had made in the plaint. So what is the procedure for appearance of the defendant? In a suit to which the order applies and the plaintiff shall together with our summons under rule 2. So together with summons under rule 2 serve on defendant a copy of plaint. Now what he will do, just a second. The plaintiff shall, together with the summons under Rule 2, serve on defendant a copy of the plain. Now, plaintiff will what do? Copy of plain and annexes thereto, and defendant met any time within 10 days. This is the prime question. 10 days. Within 10 days, he has to give his appearance in the summary procedure and enter an appearance either in person or by pleader. In either case, he shall file in court or address of which the service of notices to him. Unless otherwise ordered, all summons, notices and other judicial processes required to be served on the defendant shall be deemed to have been duly served to him if they are left at the address of given by such service. On the day of entering the appearance, notice of such appearance shall be given by the defendant to the plaintiff's pleader, or if the plaintiff sues in person, the plaintiff himself, either by notice delivered at or sent by the prepaid letter. If the defendant enters an appearance, the plaintiff shall thereafter serve a defendant a summons for judgment. Now, what he has done, he has appeared. Now, again, the plaintiff will serve summon for defendant. Summon for judgment. And that he will do under 4A. Form 4A, Appendix B, or such other form as is returnable not less than 10 days. Now, this is also 10 days, returnable under 10 days. From the date of service supported by an affidavit verifying the cause of action and the amount claimed and stating that on this behalf there is no defense to the suit. Okay. If date of supported by an affidavit verifying the cause of action, the defendant met any time within 10 days. So 10 days from the service of such summon. By affidavit disclosing such fact as may be deemed sufficient and entitle him to defend. Apply on such summons for leave to defend his suit, and to leave to defend may be granted for him unconditionally or upon such terms as may appear to the court or judge to be just. Provided that leave to defend shall not be refused unless the court is satisfied that the facts disclosed by the defendant do not indicate that he has substantial defense. That leave to defend shall not be refused unless the court satisfied that the facts disclosed do not indicate that special defense to raise or that defense intended to be put by defendant is frivolous or vexatious. Shall not be refused unless the court is satisfied. Okay. तो लीव टू डिफेंड आपकी रिफ्यूज़ हो सकती है अगर आपका सब्सटैंशियल डिफेंस नहीं है या आप फ्रिवलेस वेक्सेशियस लग रहा है. प्रोवाइडेड फर्दर where the part of the amount claimed by the plaintiff is admitted by the defendant. Now part आपने admit कर लिया by the defendant as to be due from him, and leave to defend the suit shall not be ground unless the amount so admitted to be due is deposited by the defendant in the court. Where the part has been admitted, leave to defend आपका जो है ये not grant तब तक नहीं होएगी जब तक आप वो जो आप deposit नहीं कर देते हो कोर्ट में. Leave to defend the suit shall not be granted. At the hearing of such summons for judgment, if the defendant has not applied for leave to defend, or if such application has been made and it is refused, the plaintiff shall be entitled to judgment herefore. I think this is discriminatory to the defendant. Like we are giving him just 10 days. We are putting so much restrictions on him for the leave to defend. We will see a judgment on this, okay? Or if the defendant is permitted to defend as the whole any part, the court may direct him to give such security with such time as affixed. On failure of such security within times affixed, the directions the plaintiff is entitled to judgment forthwith. The court and the court or judge may, for the sufficient cause of excuse the delay in entering appearance or in applying for the leave to defend. जो sufficient cause में दे रहे हो तो हम excuse कर सकते हैं delay. Power to set aside decree. After the decree of the court under special circumstances, set aside the decree, and if necessary stay or set aside execution, may give leave to defend to appear the summons, defend the suit if reasonable to do so. Power to order bill etc. to be deposited with the office of the court. In any proceeding in this order, the bill, hundi or promissory note on which the suit is founded to be forthwith deposited, and may further order that all proceedings shall be stayed until the plaintiff gives security for the cause thereof. Recovery of cost of noting non-acceptance or dishonored bill or note. The holder of every dishonored bill of exchange or promissory shall have the same remedies for the recovery of the expenses incurred in noting the same for non-acceptance or non-payment or otherwise by reasons of such dishonor as he has under this order for necessary amount of bill of note. Save as other provided by this order, the procedure in the suit hereunder shall be same as the procedure in suit instituted in ordinary manner. Procedure in suits hereunder shall be the same as procedure in suits in ordinary manner, but ये ordinary नहीं है. This is summary procedure and it is a little bit okay, बढ़िया है, ठीक है. Now we'll do the rest of the orders in the next session. Till then, stay tuned. Hit the like button, subscribe to my channel, and yeah, have a good day. Enjoy. Bye bye.